Explaining to you what the INA is and how the US government is using this law to lawfully deport individuals out of our country. INA stands for the Immigration Naturalization Act of 1952. It was sponsored over 70 years ago by Senator McCarran and Congressman Walter. It defines who can enter the United States, who can stay, and who can become a US citizen. It establishes different visa categories and regulations. It defines the grounds for inadmission, not allowing someone in, and deportation proceedings. It outlines the immigration naturalization process and enforces immigration laws. Section 237A of the INA applies to non-citizens and legal residents and those individuals that have offenses in these 8 categories. Number 1, CIMT, which stands for Crimes of Moral Turpitude. 2, Aggravated Felonies. Number 3, Controlled Substance Violations. Number 4, Firearm Offenses. Number 5, Domestic Violence, Stalking, Child Abuse. Number 6, Failure to register as a SEX offender. Number 7, Multiple criminal convictions together. And number 8, which is other, terrorism, espionage, or national security. Now, these offenses do not have to be federal crimes. They can also be state crimes. The number 1, which is moral turpitude, includes things such as fraud, burglary, theft, assault, murder, manslaughter, SA, perjury, bribery, some DUI, recklessness. And in section 237A, 2AI, it states that any alien who is convicted of a crime involving moral turpitude committed within 5 years or 10 years in the case of a lawful permanent resident after the date of admission and convicted of a crime for which a sentencing is 1 year or longer may be imposed as deportable. If you are undocumented and you came into this country within 5 years and you committed a crime, or 10 years if you are a lawful permanent resident under these general categories, then you would be eligible for deportation. The second one is a little bit more serious. That includes aggravated felonies. And sometimes those first categories, moral turpitude, can be upgraded to aggravated felonies. Recently, the INA was amended under the Laken-Riley Act of 2025. It was signed by Donald Trump on January 29th, and it amends the INA significantly. It modifies 6 sections, including Section 212D5, 235B, 236, 241A, 242F, and 243. It was named after a woman named Laken who was 22 years old, a college student, and she was unalived by an undocumented man. This law now makes it easier for the government to detain and deport non-citizens. Non-citizens that are charged with, arrested for, convicted of, or admit to certain acts, including burglary, theft, larceny, shoplifting, assaulting an officer, death by bodily injury, and it also allows the state to sue the Department of Homeland Security and the federal government for certain things. Now, you're probably wondering if you are in one of these categories as a non-citizen. A non-citizen is someone who is a lawful permanent resident, a green card holder, a visa holder, refugees and asylees, undocumented, so you don't have any of these other legal statuses, TPS, DACA, and U.S. nationals like American Samoas. Before the Laken-Riley Act, if you were accused of a crime, you would not be detained until after a conviction is found, a guilty verdict, or sentencing. But under the new Laken-Riley Act that was signed in January of 2025 by President Trump, now you will be detained without bond as soon as an arrest is made or a charge, and there's no guilty verdict needed. Under the Laken-Riley Act, these 8 categories have been expanded. So now it includes things such as petty theft, burglary, simple assault on an officer, state-level CIMT, so crimes involving moral turpitude. The process would be something would happen, like an incident or a crime or a potential crime, and if there's cause, then you can be arrested and then be detained. And under this Laken-Riley Act, no bond is allowed by judges. So, under the Lake and Riley Act, here are some of the new state mandates. Section 212D5, the Attorney General can sue DHS, the Department of Homeland Security, if the state believes that the government is giving or granting too many paroles or passes during emergencies. In Section 235B, states can sue DHS for allowing individuals in if the state determines that allowing individuals in and not denying more entry to those individuals, even in the case of lawful or humane situations, that if it hurts the state, then the state can sue the Department of Homeland Security. In Section 236, it says that more people must be detained without bond. Section 241A2, it allows the state to sue DHS for not detaining someone with deportation proceedings or deportation orders if the state finds that that individual is harming the state. Section 242F, it limits what the courts can and cannot block when it comes to DHS actions, such as parole, detention, and bonds. States can sue and challenge DHS in court for issuing visas that conflict with the law if the state suffers harm. For example, if the state is spending too much money on public services or schools or law enforcement that is harming the state's budget, then they would be able to prevent DHS from granting certain visas. So, in summary, if you commit a crime, you will get punished. If you're a non citizen, you will get detained immediately, and then you will go through the deportation proceedings, and a judge can determine if you are deportable or not, based on the INA Act of 1952. So, what the government and others may say is that we're not punishing you again, we're just enforcing immigration laws, which are civil proceedings, completely administrative.